Mr Speaker, I just want to go back to when this bill was first introduced and just remind the House that it was a bill that was introduced by the Labour Party. It was introduced by Clayton Cosgrove, and it was introduced in response to an actual event that had happened with regards to a Blenheim man in 2005 dying after he was restrained by a bouncer. And it was after that tragic accident, Mr Speaker, that Labour responded and saw a need for this bill to be reviewed, Mr Speaker, and that's exactly what happened. And now it's taken a bit of time for that side of the House to actually push this legislation through. And it would have been good, actually, if they had taken into consideration the well-being of New Zealanders and the fact that they are at risk out there with respect to this industry not being regulated, and that there have been a number of incidences that call for the regulation of this industry, but instead the only thing that has prompted them is the Rugby World Cup being on the horizon, rather than a genuine concern for the safety of New Zealanders. So the reason that this is now being pushed through is so that it can be put into place by June 2011, so that it can be in place by the time the World Cup is held in New Zealand, and that is good, but it could have been done a little bit earlier, but never mind, the time's gone, and here we are discussing the bill in the House now. Mr Speaker, there are a number of things that I want to discuss with regards to this bill. There's three main provisions with respect to this bill, and the first one is licensing requirements, so including police checks for criminal convictions. So these will be extended to cover a wider range of security-related activities, in particular crowd controllers, including bouncers, bodyguards and private security staff guarding people in legal custody. And I just want to go back to something that Hone Harawira said, because actually when I first picked up this bill, I did think a large proportion of this workforce is actually Māori and Pacific. Many of them have fallen into the jobs largely because of their size and the fact that they actually suit the work, and so they get hired into these positions. And so, Mr Speaker, I do agree that there does need to be a level of licensing. There does also, and part of this bill is with regards to training, need to be a level of training, not only to protect the general public, but to also protect the people that are working these jobs, to ensure that they're well equipped to deal with the situations that they encounter, keeping in mind that many of these encounters that they have can be a little bit worrying, can involve alcohol, and so it is important that they do have the right training to be able to deal with it. Mr Speaker, with regards to the licensing requirements, the one thing that I would want to see is that there is a level of discretion with respect to the licensing authority who will be issuing these licences, because I do know a number of people that are practising in these particular roles who have been doing so for years, who actually do have previous criminal convictions going back many, many years, but who have not had any problems since they've been in these positions. So say they've been a security guard for 10 years, they had a criminal conviction that may actually have involved violence 20 years ago, but over the whole extent of their time doing this, they've had no issues. I do think that the licensing authority may need to take that into consideration, particularly if this person or some of these people may have actually intended for this to be their career that they were going to enter into and intend to stay in that career for a long period of time. If they've had no issues, despite the fact that they do have a criminal conviction, if they undertake the training and are able to achieve the standards that are set out by the licensing authority, then I do think that there should be a level of flexibility there, a level of discretion that the licensing authority can exercise to ensure that they aren't convicted twice over in their lives. I mean, if they've already served the time, they've come out, they're serving a decent life and they're working a job in one of these types of positions and they're doing so safely, then I don't think that we should be punitive towards them or punish them in any way. So that would be my one concern, and it's something that I think that we'll be bringing up in committee stages as well, to ensure that there is a level of discretion. Now, Mr Speaker, one thing that this does do is it does actually put us into line with the UK and Australia with regards to the regulating of the industry. The private security staff will be required for the first time in New Zealand to undertake training if their job is guarding property, guarding persons or keeping order among groups of people. Essentially, training will be required if the nature of the work is such that there is a significant risk of physical violence occurring. The details of the training requirement will be made explicit via order in council. One of the other provisions, so the third provision, is that there will be a dedicated enforcement body. The Complaints, Investigation and Prosecution Unit will be created to ensure compliance with the new legislation, and there will be heavier penalties for offending. A penalty for unlawfully employing an unlicensed security guard will go up from $2,000 to $20,000. The penalty for unlawfully operating an unlicensed business will go up from $2,000 to $40,000 for an individual and $60,000 for a company. Now, Mr Speaker, referring back to that incident with regards to the person that was killed at the age of 25 outside the Blenheim nightclub, that is only one of many situations where things have gotten out of control and the person that is in that security position has come to some sort of altercation with the member of the public, and this has happened. There's another example that the father of that Blenheim man actually refers to, and it's something that he found out about after having gone through this with regards to his son's death, and that was where he found out from another woman that her son was actually thrown down the stairs by a bouncer and that he now has brain damage. So, I mean, there are incidences. I'm sure that many of us in our own lives have seen altercations, maybe in our earlier days, not these days, outside bars where there have been altercations between bouncers and members of the public, and where at times you do wonder whether they've taken it slightly too far, the security person, or on the other hand, where the member of the public has just provoked, and actually the altercation has been on both sides of the tail. So Mr Speaker, we will be supporting this legislation, but there are questions that we do have. The first that I've raised earlier is just with regards to the discretion that the licensing authority will have with respect to actually granting the licences, taking into consideration criminal convictions, but not being too punitive if that person has been in that role for a long period of time particularly. The other issue that we do have, Mr Speaker, is with regards to clause 66 of the bill, which restricted the taking and using of photographs and other recordings by a private investigator without consent. The committee, as we've heard divergent views on this topic. Some argued that the restriction would inhibit the work of private investigators and that the public interest in investigating criminal activity outweighs public privacy. Others argued that the clause should be retained to avoid abuse and unfairness. The committee recommended, despite concerns from Labor and the Greens, that clause 66 be deleted and a new clause 106A be inserted to create a regulation-making power to allow codes of conduct to be made for licensees. And Labor opposes this change, Mr Speaker, and it's not in favour of deleting clause 66 and replacing it with a regulation-making power because of the fact that the outcome of the Law Commission's privacy review is uncertain and the shape of the new legislation in the privacy area is not clear. And also the amendment could give private investigators wider surveillance powers than enforcement agencies such as the police. Labor's preferred option is to proceed with clause 66 as introduced and to consider reforming this provision once the Law Commission has released its final report. The Commission has already recommended that Parliament enacts the Surveillance Devices Act, which will include new offences relating to recording, trafficking and filming people. Mr Speaker.
I call